We really need sustainable behavior by enterprises because unsustainable behavior is also a financial risk. What I think is, as we have seen during the last years, that pure voluntary standards are not enough to really move the needle on corporate sustainability. We definitely need legal regulation.
Hello everyone and hi from SoS, the Sustainability osapiens Summit 2025 from Mannheim. Today we are recording live here our Beyond Compliance podcast with Dieter Overath, and we have a special guest here, Anne-Christin Mittwoch from Graf von Westphalen, right? It's a law counsel firm. Anne, great that you are here today. Can you shortly describe what you are doing, what your research is about, and give a short introduction?
Yeah, thank you, dear Julia. Thanks for having me. Happy to be here. Yes, as you said, I am an off counsel at Graf von Westphalen, which is a major law firm based in Germany. And there I am a member of the green trade team, meaning that we're dealing with everything that you can qualify as being relevant for sustainable trade. So it is company law, but also contract law. It also covers different topics of public law and, of course, all the legal acts of the European Union that are now so relevant. And besides, I'm also a professor of private law, European and international business law at the Martin Luther University of Halle-Wittenberg. So because you asked about my research topics, I try to make it quick here. I'm focusing mainly on company law, but also the law of the financial markets, and therefore dealing with sustainable finance, corporate sustainability, and also a lot of international and European law that's going on right now. And as we all know, that's a lot.
Yeah, definitely. Absolutely. And I mean, this is the right place where we are, right? Because international law, especially from the European Union, is what we are talking about here at SOS. It's all about regulations. Can you maybe point out how these regulations changed the corporate law in the last years? I mean, we had a lot of new regulations, a lot of regulations that were delayed, but then maybe came back. What did change? Maybe what did the companies say? What is your experience in that?
Yes, I think what we are observing or have been observing during the last years are really structural changes of the corporate landscape in Europe and the member states. And the European Commission has started out the sustainability challenges by mainly dealing with information duties. So there was not so much legal obligations that were imposed on corporations from the beginning, but it was all put on the market. So if investors and consumers had enough information on companies, they then would, so the assumption of the Commission, they then would support sustainable companies. And this is a plan that has, of course, many advantages and disadvantages. But during the recent years, we have observed that this process is now being shifting more towards real core corporate law. So what we have seen, especially with regards to the CSDDD, the Corporate Sustainability Due Diligence Directive, is that the Commission has tried there to really go to the heart of company law and alter the purpose of companies. So to have to insert a regulation that obligates corporate directors to take sustainability aspects into account. So this would have been really a pivotal change, a paradigm shift, you could actually say, of corporate law in a way. As we all know, is that this proposal has not been politically accepted. However, what we can see, if we try to boil it together, is that we have a shift from mere information duties to real legal obligations to act. And this touches corporate law in its very basics.
Understood. Well, that's a lot, actually. And it sounds really complicated, to be honest, right? But for sure, it's really an honor to have you here, actually, today, because you're the expert, right, when it comes to corporate law. My question now to you, Dieter. Now we heard a lot about the theory about corporate law and all the changes. What is your experience? Did you, or are you wishing that maybe some of these corporate laws would already exist in your time when you were founding Fairtrade Germany?
30 years ago, that was not a topic. Even sustainability was a topic just for some people of the CSR department. But for me, it's really interesting because the background of all the regulation was that things are going wrong. We have violations of human rights, we have child labor, and also things are going wrong in the environment. And that is something where we all want to come to a better level. And that is, for me, is it more a question of law to solve these problems? And what happens if we all know the famous risk map? And if it's green, everything is okay, and it can go on. But if it's yellow or red, so how do you see that these laws are improving situations where we all thought, yes, we need these regulations to improve the human rights situation? Let's take the cocoa issue. We all know that child labor goes on. It has not stopped because of just one regulation. And that is something where I'm asking myself if this leads to an improvement, and what happens if, still cases are arising.
Yeah, very good question, Dieter. Thank you. It is. I think you mentioned the risk map, and you mentioned, Julia, that the regulation is very complicated, and these are two important issues. So, as the regulation is indeed very complicated, we have seen, and we're right now observing a backlash against ESG. Yet we still have a lot of regulation in place, and more is about to come. So, how can we make it easier for corporations so that it really makes sense and moves us forward? And one thing that is being done right now, especially when we look at the financial markets law, is that labels are being invented. So you mentioned the colors green, orange, and maybe red. So this is an instrument to make it a bit easier for corporations and then for, again, consumers and investors, for the market to see how corporations act. And when we look back at your experiences, you were the founder of the Fairtrade label, as I was informed. Now we have a process of not only labeling good products or sustainable products, but also labeling sustainable companies. And this is, of course, for consumers and investors, a very important instrument to recognize what is maybe a good choice. And what happens if things go wrong? What happens if these labels are false, or if they are obtained because of deceit? Then, of course, we have the situation where lawyers, again, come into the picture, and we have the whole litigation field. So, of course, this can still happen. We don't have had so many cases yet, especially in Germany, but also in continental Europe, because the regulations that have been put into place now, they don't really have much sanctions in them. And if they are not yet implemented to a stage where we can really come up with sanctions. But this is, of course, something that we're going to see in the future. So fines, then, of course, civil law procedures, this is all possible.
Maybe when you have a look to the whole supply chain, and you mentioned it's not about the product, it's about the performance of a company. And let's take the example of child labor in cocoa, where we all know that an importer, an exporter, a trader, a retailer, and the brand whose name is on the chocolate or whatever. And for me, it gets a bit complicated when we discover cases who at the end, within quite long supply chains, has a responsibility. And my impression sometimes is that the game is starting to pass responsibility to the next part of the supply chain, who is, let's say, closer to the victim or to what happens. And that is something, if these regulations and to see it from the side of the laws can address the responsible persons or better companies, and that is something who has to improve,
right,
if something happens.
Thanks. This is a very good question because we're observing responsibility being assigned to consumers and assigned maybe to NGOs that help potential victims of human rights violations to fight against the corporations that are violating them. And who should be responsible in the end? Shouldn't it be the corporations? So the supply chains are a very good example in this respect because the CSDDD, the Corporate Sustainability Due Diligence Directive, has actually many legal instruments that help in that respect because the supply chain is being considered to be the whole chain of activity of a corporation. And what we're observing now with the omnibus proposals, with the backlash against ESG, is that this broad notion of a supply chain is being reduced just to one tier. So that means each corporation is responsible only for their own business actions and for that of their one tier, so their first tier supplier. Then we would leave out the whole rest of the supply chain. And this would, of course, be not very good and not helpful with regards to the sustainability transformation. Maybe another aspect is a stakeholder participation. What we can also observe regarding corporations is that corporate decision-making is not longer possible in a black box room behind closed doors. Shareholders or stakeholders, besides others like shareholders, have to be involved. And this is also something that the CSDDD brings about. And that has, in my point of view, not gained full or enough attention because this is a powerful tool. We have in Article 13 of the CSDDD an obligation to really hear out stakeholders, to bring in stakeholders for the whole process of due diligence in the supply chains. Meaning also that we would hear potential farmers or smallholders in African countries on the cocoa farm, for example, with regards to the decision-making of the European mother company. This is something that is also being tackled in the omnibus regulation by reducing the scope of the relevant stakeholders. But it is something very interesting. This February, I was at a conference in Nairobi and talked to the people there and to smallholder and small businesses. And this is the instrument, the stakeholder participation, that could really move the needle. Yet it is now being discussed, and maybe we will see in 1 year that the stakeholders that are relevant in that respect are narrowed to basically the employees of the corporations in Europe. So this is something that we will closely observe and that we're interested about.
Yeah, it's an interesting question because we all know with a law or regulations, a problem doesn't disappear automatically. And I'm really glad that you mentioned that only a stakeholder-driven initiative can improve things because when the brand itself doesn't feel responsible, when the first mile says there's so much price pressure on us that child labor is, let's say, one outcome of the bottleneck, then of course we will not solve the problem just with a new regulation here in Europe or wherever. And that is something where your message that stakeholder view and looking all together to a problem and finding solutions is, let's say, the main tool. Because what we have seen here in the conference, that the Global South is not very present in the whole discussion. They feel the pressure, but they have really no tools in their hands.
Yeah, absolutely right. I mean, we have to see the process as a real multi-stakeholder approach. Of course, consumers can do something for sustainability. Of course, states are obliged to implement the international contracts. And of course, the legislators of the European Union and of member states are responsible. But it's also companies.
Yeah.
And companies make a big impact. So they all have to move or to work together in order to really move the needle. And then I think that even the best legal acts and laws are not really useful if corporations don't really stick to them, maybe even go beyond and take on the idea of sustainability and really implement this in their strategy, in their corporate strategy. That is important.
I would like to follow up on that nice statement you just gave us. Would you say, in all, that these European regulations are a burden for most of the companies, or can be a chance for them? How would you describe this?
This is a very good question that I'm being asked very often, of course. And I'm always also interested in hearing an answer by the corporations themselves, even here today and tomorrow. I think the view on that is very differentiated at the moment. Yeah? So of course it is a chance. I think we can all agree on that. But we can also see many, many companies that consider it as a burden. Why? Because they often have a kind of tick-the-box mentality. So we have to obey the laws, tick the boxes, and then we're all set. The companies that embrace the legal rules, they are probably going beyond that even today. So it is, again, the mindset. So what I think is, as we have seen during the last years, that pure voluntary standards are not enough to really move the needle on corporate sustainability. We definitely need legal regulation, even if it is considered as a burden to some extent. It won't go without it. But I think the fact that it is a chance for businesses is definitely to be emphasized very much. So it's definitely a chance. And
Absolutely.
maybe one last aspect on that. We really need sustainable behavior by enterprises, because unsustainable behavior is also a financial risk. And if we want to talk about profit maximization and financial stability, then we also need to talk about sustainability. Because if we act unsustainably, if we continue with business as usual, this will be very, very expensive in the future. The transformation is expensive. It does not get cheaper. So yeah, I think it is a big chance.
Absolutely. That's great to hear. What are your thoughts about this, Dieter? Do you also think that these are now chances for companies?
Yeah, if everybody can organize themselves to improve things, why we didn't it 10 or 20 or 30 years ago. All the reasons for legislations are on the ground, and they are, let's say, in Africa, Latin America, less in Europe, but still also some here. And that is something where I think the pressure to improve things after all decades of doing nothing or not doing enough, not doing nothing. And for me, it would be interesting, where do you see yourself in this whole stakeholder issues? Because you have to be neutral. You are not married with any company or player within the long supply chain. Because for me, it gets a bit interesting when we have a so-called yellow risk map, where we all know, okay, we have to improve things. And of course, the penalty at the end is one really tool. The German law, I think it's up to 2% of the sales volume, which would be quite a lot. But for me, there's no outcome at all. So it's still a question if it's a really weapon threats. But the question is, what happens when things are not going well? Which is, let's say, more normal as everything goes well. And where do you see yourself in this in-between, let's say?
Yeah, right. This is difficult to answer. I mean, firstly, as an academic, I try to work on the best solution within the legal landscape. And the same as an off-counsel at Graf von Westphalen, where we, of course, have to help clients to solve their legal issues. And we have great legal uncertainty at the moment, so a lot of questions to be answered. So what we try is to analyze and observe the legal landscape that is now emerging and that has already emerged so far. And we try to improve the solutions that are already there. Because what we have to deal with are a lot of incoherencies, because we have a lot of silo thinking regarding the sustainability transformations. So on the one hand, we have the financial markets. So we have all these financial people, they do financial law.
They do like this or this.
I mean, we have great dynamics on the financial markets. So
Yeah.
we have a great push towards sustainability there. Then we have corporate. And of course, corporate is never separated completely from financial markets, but there's another way of thinking. So we have a silo there. Then we have the whole contract law. And then we have all the human rights law, which is public law. So in the legal landscape, in the legal world, we have civil law and public law. So we separate this. So people that do human law or human rights law, they really usually don't talk with financial people. So this is something we really have to work on. And this is something where I see myself in, and also our law firm, that we try to improve this. We try to get rid of the silos, make the legal landscape more coherent, make it easier for corporations to follow up, because we don't have sustainability departments in every enterprise, obviously. Even in small, medium enterprise, this is hard. For them, it's even more expensive. So there are different departments of enterprises that deal with different things that all are connected to sustainability. And we try to help there and make the processes more efficient. And when things don't work out, then we have legally at the moment, we actually rely very heavily on the market mechanisms. Like I already said before, we rely on consumer choices and investors' choices. We rely to a large extent on reputational effects. We don't impose that many fines. We have in the German Supply Chain Act, we have the possibility to impose fines, as you just said, up to 2% of the net turnover.
Yeah.
However, that has never been imposed. So that has never been really effectively used. So the real heavy sanctions are they are not that much in the picture. It's more that we rely on market effects. This is what we see the most. This does not mean that this won't change in the future. So the CSDDD also uses the instrument of fees. But it is really the market and the reputational effects that at the moment play the biggest role.
So to sum it up, we actually would need more sanctions, right? It would make sense to be maybe more consequent, right?
Yeah, I mean, probably it would really be useful if we have victims of human rights violations. If there are victims of violations of environmental law,
they are still
to compensate, they are, of course. So whenever this is the case, then it would be wise, I think, to have compensation for them, to compensate their damages. And this is something that the CSDDD would allow. But right now, the omnibus proposals want to remove that instrument from the legal act, meaning that we strip the potential victims of human rights violations, of environmental damages, of their compensation. And the compensation, when we, for example, look at the Kick case, which was the famous German case, the company Kick and the fire in the supply firm in Pakistan, had the first legal lawsuit in Germany about that. We observed that the fine or the compensation that they sued for was not high. Yeah,
that's true.
It was about 15,000 euros, so nothing for Kick. So a fine, a percentage of the net turnover would be that much higher. On the one hand, this means everything for victims. So this is something that, like from the victim perspective, would be very important to have. And then on the other hand, for the corporation perspective, I don't think that they have to fear a real tsunami of legal lawsuits coming up on them.
Yeah,
so
that's totally true.
This is something I would strongly, argue
right?
for and advise.
Yeah. So on the one hand, more sanctions, right? But on the other hand, as maybe a goal for working better together, you also mentioned collaboration. Maybe I would like to hear one last tip from both of you, right? What would be your suggestion for companies working on these regulations? Your topic or your point of view is like more from the legal perspective. What are your wishes in order to make these sanctions, what we were talking about, actually real? Do you have any ideas, or what would you apply for? Let's call it that way, maybe.
Yeah, I mean, we don't, like, as lawyers, we want to avoid sanctions. Yeah, we want companies to behave sustainably.
Yeah.
I think there's the notion that lawyers come in when there's a real problem, but we can also advise, like from the start, and help corporations develop their sustainability strategy, help them to follow up on the different legal acts that are out there, and they are, I mean, indeed, they are complicated. Let's face it. Yeah? So we can help there. And I think, we don't maybe, or we shouldn't maybe focus too much on the sanctions as the great fear being upon us, the sword of Damocles, but more on the chance, as you suggested earlier, and try to implement the acts that are out there, the must-dos, so to speak, and then even think about the can-dos. Yeah? What can I do when I go beyond compliance? Yeah? So I think this would be a good idea. And I'm happy to help from an academic point of view and by advising at Graf von Westphalen.
Thank you so much, Anne-Christin. Dieter, one last advice from your side. What would you advise companies to do?
Yeah, I'm still at the cocoa case. And still, we all know there are around 700,000 or 800,000 children working in the cocoa sector in Ivory Coast and Ghana. There was just 1 week ago another reportage, and you find these children. And that is, for me, a bit black box. We all know the income situation of the people there, of the parents, is one reason that children do this work and they don't go to school. And that is something where we are in an in-between area where price pressure is one of the reasons who still supports in a negative way child labor, and that every company in the supply chain has a certain responsibility. But okay, you can't judge Cargill, you can't judge Callebaut, you can't judge Ferrero or whoever has a role in this supply chain. And that is something where the solution is, let's say, in the stakeholder. And when you go into detail into certain problems like child labor, it gets complicated. And that is, of course, then when you judge a company and you know these cocoa beans, at the end, then you need transparency, came into a Ferrero or Ritter or whoever chocolate, then you can put your fingers on the sea. But we all know we never will get these kind of outcomes because the way of a cocoa bean is quite long when it gets into the supermarket. And that is something when we have identified a really crucial problem in the environment or, let's say, in human rights violation, what to do before sanctions. And that is something, and child labor is still an ongoing topic in West Africa.
Absolutely.
No?
So
and
actually,
that is something where we talk about impact, but we also have to talk about solution. And if all these regulations doesn't lead that in 5 years' time we have less child labor, then the question is, so where's the impact?
Absolutely. So actually we need more transparency as well. I'm
impact-driven and looking to the first mile, and the question of pricing, pressure, and income is not a violation of regulation, but it's, let's say, something which supports, at the end, supports in a negative way these things. And that is something, where is this addressed? And it's not a question of lawyer, I know, but I'm happy that you see your role not only when something went wrong, that you see your role, let's say, that less things are going wrong, but this, what I explained with child labor is one topic where probably it's not only a legal one.
Absolutely. Thanks a lot for your advice, both of you, for being here at SOS. I would say let's collaborate, right, and work more on transparency.
That's the overall message here.
Great.
Definitely, right? So I guess we are on the right place here in Mannheim at SOS. So thanks to both of you. And if you guys would like to collaborate with us, then meet us at osapiens. This is our international global network where all of us can collaborate.